Good afternoon, everyone, and welcome to the Queensland Media Club. I'm Marlina Whop from 7 News. First of all, as a Gumulgal person of Mabiag Island in the Torres Strait, I want to respectfully acknowledge the traditional custodians, the Turrbal and Yagara peoples, and my deep respect to the elders. I am pleased to welcome our speaker for today, the Honourable Deb Frecklington, Attorney General, Minister for Justice and Minister for Integrity. Before we invite the Attorney General to the stage, some background. Deb Frecklington was first elected to the Queensland Parliament in 2012 and holds degrees in law and business. She says her priorities include delivering a justice system that puts victims' rights first and enhances community safety, while also boosting the capacity of justice services to expedite cases, increase support and transparency for victims, strengthen regional access to justice, implement reforms to enhance transparency and accountability, and support initiatives that uphold public trust in government institutions. We look forward to hearing insights on the government's next steps and policy reform to keep children safe. Please join me in welcoming the Attorney General.
Thank you, Marlina. It is wonderful to be here. So thanks each and every one of you for coming along today to hear from me, but also can I please extend my acknowledgements to the Queensland Media Club for inviting me. It is wonderful. This is my first time I have spoken, I think, at the Queensland Media Club, so thank you to each and every one of you. I'd also like to acknowledge my ministerial colleagues who have come here today, in particular the Minister for Child Safety, Amanda Cam. We have the Minister for Women and Indigenous Affairs, Fiona Simpson. I'm looking around for her. We have the Minister for Police. And importantly, for next week, we have the Treasurer of Queensland in this room. Thank you for taking your time away from those budget papers for being here today. Can I please as well extend my gratitude and thanks to each and every one of the Queensland Media Club sponsors. It is important that you do continue to support these very important events, and I thank you very much. And today is a significant day. It is a big day for anybody who cares deeply about the future of Queensland children. As Attorney General, with responsibility for ensuring our kids are safe in our community and protected through the courts, I'll be announcing a nation-leading initiative from the Christopher government to prevent harm to children, particularly sexual abuse. Today's subject matter is in part confronting, if not distressing. But if we are to rebuild a child safety system that absolutely acts in the best interests of the child, truth and transparency cannot be a casualty. So thank you in advance for your understanding. After all, we are all invested in our children. We are on this journey together. Now, ladies and gentlemen, can there be a more brutal betrayal than child sexual abuse? I sincerely doubt it. For those families affected, it's hard to imagine a deeper lament, a greater tumult, a wilder fury. And when I grieve the damage of child sexual abuse, a part of me knows that if it takes a village to raise a child, it takes a society to protect them. Every harmed child and every impacted family is our collective pain. Because every child's internationally sanctioned right to special safeguards and care is a shared responsibility. A mutual obligation on governments, legislators, police, the courts, communities, neighbourhoods, and the myriad organisations directly engaged in the care and guidance of children. the state's role and reach is paramount. Making laws, setting safeguarding strategies, and moreover, holding delivery responsibility for a wide range of child safety measures and services inside an overarching child protection system. When that system is repeatedly questioned, let alone suspected of failing, it's a government's duty, in fact a cornerstone of our democracy, to seek answers. And that's exactly what we did when the Crisafulli government, just 10 days after taking office, ordered a review into the state's child protection system. Now, Queenslanders not only backed it, but they sweated on it, in the expectation that we would do as we said we would do before the election and respond with decisive action. At 500 pages, the Child Death Review Board's in plain sight. That report lays bare the crimes and pernicious methodology of Ashley Paul Griffith. Equally, it eliminates the insufferable ramifications for children and their families of a pedophile on the loose. Griffith was sentenced to life. He was sentenced to life imprisonment in November 2024 for 307 offences related to the sexual abuse of 69 children, mostly under the age of 5. These horrendous events spanned 2 decades before he was finally detected and brought to justice. In fact, at the time of his offence in August 2022, he had no pending investigations, no charges, no convictions, and satisfied all requirements of working with children and Blue Card. This evasion was not perpetrated on the margins, Griffith did not cling to the sidelines, move in the shadows, or shelter on the periphery of everyday life. On the contrary, he operated in plain sight. A regular, highly visible presence for thousands of working parents who had trusted him with their children, their babies, their toddlers, their preschoolers, at 22 different early education and care services across Queensland. Families have been shattered by the harm Griffith inflicted. They will never be the same. From a qualified early childhood educator, they expected nurture and guidance, and above all, protection, security, and safety. Griffith manipulated this accord to engineer a structure of opportunity. And yet, through the resolute work of the Child Death Review Board, we learnt his duplicity was abetted. Deep-seated systemic flaws conspired to run interference on Griffith's behalf. With 18 points where his offending could have been detected or disrupted, including 5 critical missed opportunities, and I'll speak more to those in a moment. However, it is essential to recognise. What is essential to recognise is it's the case that whereupon the basis that we commissioned and requested the Child Death Review Board to examine the legislative framework, the policies and the practices of the state's early childhood education and care sector, and how they interact with our police service and Blue Card services. Taking the parts together, the board's 10-month review identified a litany of failure: siloed information, fragmented responsibilities, insufficient thresholds for action against offenders, poor record keeping, enormous sector and interagency gaps, Today, I'll explain how the Christodoulou government will respond to these glaring and costly oversights. But first, if we are to deliver a brighter and a safer future for every Queensland child, we must reflect searchingly on the weaknesses of the past. In December 2017, the Royal Commission into Institutional Responses to Child Sexual Abuse was delivered its final report. Queensland's former Labor government accepted the Commission's 39 recommendations to establish and embed a reportable conduct scheme. In short, a reportable conduct scheme provides a framework to report and investigate allegations of child abuse which may not meet the criminal threshold. And in June 2018, 8 years ago, then Premier Palaszczuk said, "The establishment of a reportable conduct scheme is a priority for Queensland. Institutions need to be accountable for the way they protect children and investigate allegations of harm, and a nationally consistent reportable conduct scheme in Queensland will ensure appropriate oversight of institutional responses." Shockingly, at the time of Griffith's arrest, 4 years after that statement was made, the former government had not acted. The complacency was a broken promise to Queenslanders and a devastating misstep for the growing toll of Griffith's innocent victims who continued to be abused. Well, how costly? The In Plain Sight report confirms, and I quote, "At least 3 up to 5 events on the offender timeline where a reportable conduct case should and would have been opened, reported to the Queensland Family Child Commission, investigated and quality assured." On more than one occasion, police were notified of Griffith's offending. But it's not hard to see how the word and the capacities of a traumatised child, relying often on the agency of a parent, can be overshadowed by what the justice system demands by way of evidence to proceed with a criminal case. I've met myself with the anguished parents of a 4-year-old in this exact situation. Now, Victoria established its reportable conduct scheme in 2017, Western Australia in 2023 and New South Wales in 1999. Griffith was finally arrested on the 21st of August 2022, with the public advised of the case almost a year later. 9 days after that, the scrambling former Labor government released a paper exploring implementation options for a reportable conduct scheme. In their review, the board openly questioned this timing as to whether it was a direct response to the Griffith case or rather a matter of good policy development. On the 19th of September 2024, during the dying days of the former Labor government and 6 years after former Premier Palaszczuk's broken pledge, a reportable conduct scheme was finally legislated. That is 2 years after Griffith's arrest, 8 years and 8 months after it was formally recommended by the Royal Commission. So Queensland families can ill afford any more delay. The Christodoulou government has fast-tracked Labor's proposed launch of the reportable conduct scheme by 12 months so that all relevant sectors, including early childhood education and care and childminding services, will be covered by the start of next month. In another important development, last month, I tabled in Parliament a separate Commission of Inquiry report into Queensland child safety system, focusing on our vulnerable children who are in care. The Christodoulou government, which launched the Commission of Inquiry, is now considering its 52 recommendations alongside this very important In Plain Sight document, and we are already seeing a chilling synergy. The former Labor government's repeated failure to make timely and sustained investment in family-based care and early intervention has fuelled a 229% explosion in the number of children and young people in residential care. It's left Queensland with 2,388 young people living in residential care. That is almost as many as every other state and territory combined. Tragically, the report found 67% of reported instances of child sexual abuse in care involved children placed in residential care. These are more catastrophic failures in child protection under the former government. By contrast, my colleague and Minister for Child Safety, Amanda Cam, who is here today, has moved swiftly in light of this report, announcing that no child under the age of 5 will remain in residential care. We'll be having more to say on the Commission of Inquiry's recommendations during the development and implementation of a whole-of-government response. But the Christodoulou government has been getting on with the priority of protecting children, Queensland children. We've passed Daniel's Law, creating a register for child sex offenders, bolstered supervision and vigilance at our early childcare centres. We've standardised child safety training, invested heavily in compliance capability, and overseen key changes that have strengthened the Blue Card scheme. At a federal level, I've pushed for changes through the Standing Council of Attorneys General, which now means information from the National Redress Scheme can be shared with Blue Card services. And in our first budget, in the face of those Labor cuts, the Christodoulou government invested $12.7 million over 4 years to secure an extra 29 early childhood regulatory officers. So as a government, we have wasted no time lowering risk and closing long-standing loopholes that had allowed child offenders to avoid detection. Today, the centrepiece of our response to deliver an even stronger system of protection for Queensland children can be announced. I announce that the Christodoulou government will invest $250 million to establish Queensland's first centralised child safeguarding agency, a nation-leading agency called the Queensland Protection Commission. Thank you. Thank you. The Queensland Protection Commission will provide a single point of leadership, coordination and accountability for child safety and wellbeing across the state. In another first, the Commission will host an intelligence hub targeted at proactive investigations. The hub will collect, analyse, connect and act on vital pieces of intelligence across agencies and sectors to eliminate the risk of child offending before it becomes harm. With these measures, the Christodoulou government directly addresses 2 flagship recommendations of the In Plain Sight report, while tackling head-on the child safety system's recurring twin fault lines, disaggregated information sharing, and the heavy reliance on threshold-based interventions. It means the government's Queensland Protection Commission will usher in long overdue focus on prevention and early detection. Because we believe that while chasing crime is a priority, protecting our children is a non-negotiable. The Queensland Protection Commission will achieve this by introducing clear and consistent oversight across multiple agencies, regulators and organisations, bridging fragmentation, gaps and duplication of the past. In a key plank, the Queensland Protection Commission will combine under its regulatory authority Blue Card or Working with Children checks, disability worker screening checks, the Reportable Conduct Scheme, child safe standards. Co-locating these critical child safeguarding functions under one leadership was a core recommendation of the In Plain site. By integrating their various data, the Queensland Protection Commission will ensure knowledge gained in one area will readily inform decisions in another, bringing accountability and clarity to all assessments and recommendations on risk, resulting in threats detected earlier, offenders disrupted, and Queensland children made safer. The Queensland Protection Commission's new Child Safeguarding Intelligence Hub will strengthen, boost and rescope investigations from a reactive approach to proactive risk detection. As I have canvassed, the insidious character of child sexual abuse means many risk indicators remain sub-threshold. That is, they do not meet the criteria for formal police investigation or action. They are dismissed unresolved. But subtle and ambiguous behaviour can reveal a pattern of grooming. Within the Intelligence Hub, a dedicated team of analysts and investigators will collect and act on sub-threshold indicators of concern. Complaints will no longer be treated in isolation, but as a part of a broader demonstrative picture of predatory behaviour and risk to children, enabling police to take action irrespective of whether an individual has been charged with criminal offence or disciplined by their workforce. Responses may include suspending or cancelling a blue card, referral to a sector regulator, or further criminal investigation. The Intelligence Hub will be supported by a purpose-built ICT platform, linking whole-of-system databases using advanced analytical tools to identify those trends and risks. So practically, what does it look like? While the Queensland Protection Commission will support better and timely sharing between major safeguarding functions, such as Blue Card and the Reportable Conduct Scheme, its Intelligence Hub will collect and explore even more information held by departments and agencies, which will be analysed holistically to reveal patterns of concern and abuse. So if you could consider this: a criminal police investigation where a childcare worker was alleged to have improperly touched a child, but the action doesn't meet a criminal threshold, and a reportable conduct investigation into a childcare worker after parents complained of concerning comments made to their child, and an investigation by the Early Childhood Regulatory Authority after being notified a childcare worker abused a child. What if I now tell you that all of these complaints relate to the same childcare worker? In the system of silos and lost opportunities uncovered by In Plain Sight, each respective agency was prone to treat those allegations in isolation. Credible reports of harmful conduct were repeatedly missed or minimised. Instead, the Queensland Protection Commission will provide the architecture to cross-reference and consolidate multiple concerns, identifying patterns of behaviour across years and settings, escalating investigations and removing workplace threats. To ensure seamless connectivity with relevant departments, the Commission staff will be permanently seconded and embedded from the Department of Justice, the Department of Family, Seniors, Disability Services and Department of Child Safety, the Department of Youth Justice and Victim Support, the Department of Education, Queensland Health and the Queensland Police Service. By integrating intelligence techniques with law enforcement and regulatory information and fostering collaboration across sectors, the Queensland Protection Commission will raise the protection of our Queensland children to heights never seen or experienced. Queensland will stand apart as a nation's leader in the protection of our children. The Crisafulli government has accepted in principle the majority of the recommendations from the In Plain Sight report. While it will be a matter for the federal government to decide whether to provide a formal response to the report, I will be advocating for some of the key recommendations to be carefully considered for Commonwealth action. We must get this right, and there is a lot of work to do. Legislation will soon be introduced to establish the Queensland Protection Commission, which is expected to start operating in February 2027. After detailed design and build work, the Intelligence Hub will be operational by March 2028. On behalf of Queenslanders, I would like to express my heartfelt thanks and gratitude to Chairperson Luke Twyford for leading the Child Death Review Board examination. Please keep clapping because I just have to get some more. Oh, that's better. Thank you. Yes, so thank you, Luke Twyford and your board for leading the Child Death Review Board's examination of system responses to child sexual abuse and mapping a path forward. The assignment was gruelling, the process of discovery grim, exacting, I'm sure, a personal toll on you, Luke, on fellow board members, and the broad range of report contributors, including victims and their families. The board's persistence and professionalism is to be applauded. In Plain Sight's arguments for reform stem from a resolve to leave no stone unturned and an unsparing commitment to detail, despite the horrors encountered. In opening up new corridors of intelligence and information sharing, the Crisafulli government is also well aware of those Queenslanders who have dedicated and devoted their working lives to protecting kids. The many people who have done and continue to do an outstanding job across agencies, regulators and organisations, I pay tribute to them. The discrete nature of this work is intense. It means the tests that you face almost daily are often borne silently. However, we need your experience and your skill. In fact, the Queensland Protection Commission will put a new focus on fully unlocking it. Queensland children must be protected. They haven't been, they can't be, and they won't be by a system that responds only after the harm occurs. That's why the Crisafulli government is establishing the Queensland Protection Commission. With proactive, multifaceted risk detection, integrated data, clear reporting channels, and advanced analytics to identify patterns of concern and danger. A front foot approach to remove the threats, to prevent abuse, and to restore confidence back in the Queensland family. Thank you.
I think we've got a fair bit to get through. You touched on a bit of the timeline there for the Queensland Protection Commission. Do you think these changes will be enough to keep children safe?
Well, great question, Marlina. And it's certainly a fantastic start. And this is what we have to do. We can ill afford any further delays, but as has been very clearly enunciated by the In Plain Sight report and, in fact, the most recent Commission of Inquiry, it is the need to focus on the failures of the past actually does inform the way forward. And this is why it must be and will continue to be a really considered response. Every single one of us in this room, would love to see that no child is ever harmed or put in harm's way. But sitting on our hands and doing nothing is just not an option for our government.
And before I throw to my colleagues at the back of the room there from the media, the Child Death Review Board made a landmark recommendation to trial an approach many European countries have taken, where victim survivors can go to a highly specialised, purpose-built one-stop centre for their forensic interview, for example, and then that interview can be recorded and then used during the court process. Will the government be backing that recommendation?
So as you will have seen, that recommendation has been accepted in principle. And our government has, and through everything you will have heard about us, is we are putting a focus on victims. We have the first ever victims minister in Queensland, and our victims commissioner also works very closely with the Child Death Review Board and, in fact, the QFCC, and will continue to work very closely with the new entity. It is important that in the consideration of all of these recommendations, that we get all of the recommendations right, the implementation of those recommendations right, because a lot of work in and around victims and the way they can go through the court system has also already been enacted, and I'm talking about the liaison service that we have done between the DPP and victims as well, to give them a seamless way to follow their matter through court.
So will you be setting up those purpose-built centres here in Queensland? The recommendation was for a pilot program in multiple sites.
Yeah, well, look, it is, like I say, we have accepted that recommendation in principle. We'll be working calmly and methodically through the recommendations and the ones that the government has now accepted in principle, and we will be working through the implications of where and how that will sit.
All right, thank you. We'll go to the back of the room now for questions.
Is that on now? Oh, sorry. Mikaela Mulveney, the Courier Mail. Attorney General, we've seen governments sit on recommendations like this before for years, even longer. You mentioned the commission will be set up by 2027 and the intelligence hub in 2028. What about the other recommendations that you've accepted, those majority that you've accepted in full? Will we see those acted upon and implemented by the end of your first term?
Well, it's a great question because so many of the recommendations feed into the establishment of the Queensland Protection Commission. They feed into the work that has to be done, not siloed, to make sure that we're sharing that information, making sure that organisations, not just government departments, regulators, authorities that sit on information can be shared within one hub. It is important that we do a staged approach to ensure that we get it right. Now, we are making sure that the legislation can come in to the Parliament. We're not sitting on our hands. We've already done an enormous amount of work to get to this stage to be able to announce the Commission. And it is important that we do that by making sure that we are looking at all the recommendations holistically. And I don't think it is a matter of just a tick and flick of recommendations. You will see that we were handed that report. The Commissioner when Luke Twyford, when he handed that report, I think it was even a recommendation that it should be considered thoroughly and with due respect, and that's exactly what we've done, and we'll continue to do that.
Hello, Attorney General. Alex Brewster from the ABC. You talked a lot about past failures. This report used Ashley Paul Griffith as a case study. This suite of reforms, would it have stopped him or prevented his offending earlier?
Well, Alex, you can never be so bolshy as say yes, but that's the answer, because that's why we're setting up the Queensland Protection Commission. The In Plain Sight made it clear the reason why, as difficult as this topic is, as difficult as hearing the story that I outlined, it is imperative that we do not repeat the failures of the past. If a reportable conduct scheme had have been brought in Queensland when it was committed to be brought in, that would have been one step. Had of agencies not worked in silos, that would have been a second step. If there had been an intelligence hub that collated that information, that would have been a third step. Now, that vile piece of work that is Ashley Paul Griffith, now he offended, like the report says, in plain sight amongst us all, amongst those silos, because he was able to get away with it. That's why we must not repeat the failures of the past. That's why in my first Council of Attorneys General meeting federally, I said, why aren't we sharing information between the feds and the states? That's now changed. And I'm extremely passionate about this because as a government, we have said from day one we want to protect Queensland children. Every government wants to do that. But we're putting into action from experts a report that has recommended that had of this been done, then those children may not have been offended against.
Hi, Attorney General. Thank you for your speech. Reece D'Allessandro from Channel 9. AG, you've said today the majority of the In Plain Sight report's recommendations are being accepted or accepted in principle. I wonder if you could walk us through which ones aren't being accepted or accepted in principle and why.
Oh, thank you very much. I'll have to just grab out my notes that I'm sitting here with. But no, look, this is why I love these Q&As that we get. But what I can say is there's 28 recommendations. We've accepted 24 of those recommendations, 4 accepted in principle or noted. Now, the reason being is one of them, for example, and I touched on federal government, of course. It is imperative that the federal government be able to look and respond as appropriate. I'm unable to accept a Commonwealth recommendation. That is up to the Federal Attorney General. But also, if I could give you an example, there is a recommendation in relation to education around child safeguarding. So whilst we accept that in principle, of course there must be more education. That is something that the government is already doing. So we've already, and I actually attended the child safeguarding training there in Kingaroy only a couple of, about a month ago, that the QFCC were overseeing. So there are elements within the report that go to, if I can say, matters such as education of child safeguarding that already happens or is in process. And the same, for example, with investigations by police that may or are already happening, that come with other implications as well, that we must accept in principle and will have very close conversations with the Treasurer of Queensland to make sure we can get as much coin out of him as possible. Is that okay, David? But it's a great question.
Hi, Attorney General. Matt Dennine from Brisbane Times. You mentioned there the need for the federal government to be involved in the implementation of the review's recommendations. I wanted to ask whether the intelligence hub will obviously presumably need quite a bit of buy-in from the federal government. have you had any conversations with them yet about how that might work? And is there much you can tell us about their view on that element or any of the broader recommendations?
Yeah, thanks, Matt. So in relation, of course, I've written and now given Queensland Government's response to Michelle Rowland, the Federal Attorney General. We have this as a standing agenda on the Queensland, the Standing Council of Attorneys General. I put it on my first meeting. I made information sharing an agenda item, and we have done a great deal of work amongst the states. At our next Standing Council of Attorneys General, we will again be discussing the In Plain Sight report. Every other state is watching us with enormous interest, and they were so excited to hear and see the recommendations of In Plain Sight. Thankfully, we have been able to tick off the information sharing map with the feds that was required, and we will continue to work with them. Each state has a different level of reporting requirements. Each state has a different criminal code. So there are some, for example, some states that have a lower level of person that could get a blue card or working with children check. So at our next council meeting, we are addressing what level we're going to meet at. I am demanding the highest possible standard, and most states would agree with that, except they've got to get their systems in place. We need to be working and cross-bordering information as well. I've been down to New South Wales and met with the Commissioner in New South Wales, who is doing great work in the cross-collaboration with agencies, but probably not going quite as far with the intelligence sharing piece that we are, but the cross-agency sharing. And they have incredible learnings that we can continue to learn from. And of course, the good thing is, I would say, is that everyone sitting around the federal table know that something has to be done. When Griffith has now just lost his appeal, and he'll end up in New South Wales facing the charges down there as well. So everyone's watching and are very interested in what Queensland has announced today. But you'd have to ask them for that comment.
Thank you, Attorney. Andrew Messenger from The Guardian. You have to forgive me, this is not a very nice subject to talk about. Most of this report, it seems to me, deals with adults who offend, but there's pretty good evidence that, by and large, the people who offend as adults first offend as children. This is a subject that came up in the Royal Commission all those years ago. In Europe, what would happen, and this has happened before, so Brett Peter Cowan, the murderer of Daniel Morecambe, for instance, offended as a child. His offending was identified, and then nothing happened. In Europe, what might have happened, or other countries, is he might have been referred to a psychiatrist and then been treated, and perhaps that would never have happened, right? What is government doing in respect of children who offend against children?
Look, it is a massive issue, and we know that I know I've had discussions with my ministerial colleague, Amanda Cam, about some of the distressing stories of children abusing other children, sexually abusing other children, and grooming other children as well. And there are procedures in place once a government is made aware of those through the Minister for Child Safety. If it happens within our system, they're in our residential care, for example, being cared by sometimes people who are just older than them as well. So they are issues that I'm not avoiding the question by any way, shape or form, but I know the Minister for Child Safety would have a much better answer on the strategies that her department put around that for particularly children in residential care. I also know that Queensland Health is investing heavily in the prevention of mental health and child sexual abuse and the offences against child on child, which is horrendous, but does lead in many instances to offences or matters when they become an adult escalating, as you've rightly pointed out with Cowan. Yeah.
Attorney General, you just mentioned there about Ashley Paul Griffith facing charges in another jurisdiction. Are you flagging that he'll be extradited? When were those charges being heard? Can you provide a little more detail about that, please?
Well, it is now no longer before the court. So he lost in his... He appealed his life sentence and... So he appealed that. He is facing numerous charges in New South Wales. I have had correspondence from both the New South Wales Attorney General. We needed permission from the Federal Attorney General and then signing off, finishing his matter, and he will be able to be removed to New South Wales to face those charges.
How soon will that happen?
Soon. Soon. Look, we
This
are
week?
I can't answer this week. The matter goes through the court to be determined. So I need to be careful with that. But to say the Federal Attorney General, the New South Wales Attorney General, and I have actioned what we can do to get him moved, but it is up to the court to make that final sign-off.
Attorney General, I just wanted to drill down briefly on the completion times or the deadlines, if you will, for the Protection Commission versus the Intelligence Hub. Given the Intelligence Hub will take a further 12 months after the Protection Commission to be established, I think it was February 2027, March 2028 for the Hub. What will happen in that 12 months and how will the Protection Commission be able to do its work without the Intelligence Hub? How will government ensure that information sharing is able to happen without the Intelligence Hub element for almost 2 more years?
Yeah, that's a great question. So what we're doing is we're doing it calmly and methodically. We've got to make sure that we do a staged approach to get it right. But already we have a group of senior officers from across those agencies that I listed who are regularly meeting around the development and the coordination of that information sharing. So we will set up the commission as a first stage. We will embed all of the different agencies into that commission where they will continue or commence the sharing of that information. Importantly though, reportable conduct scheme starts on the 1st of next month. That is happening within the QFCC. So then what we will do is we have seconded or will be seconding from the start date of the commission people from those other departments who will work and be embedded within the Queensland Protection Commission, already sharing that information. The actual ICT factor of the Intelligence Hub, which is already being developed and worked on, we need to make sure we get the systems right so the go live can be completed and go to the extent of the long-term investigation, intelligence gathering that will pick up those repeat offenders that we may not have picked up beforehand. But it is important to note that already we are sharing information with there are already former police officers embedded within the QFCC to start looking at how we can make sure that we're sharing this information across agencies. We also need to get it right. We need to make sure the legislation is correct with information. It is vitally important, and make sure that agencies don't just have a drop-dead date to start something. We've got to get that staged approach right.
How does the hierarchy of the new commission, how will that actually work?
Yeah, so the commission will have a commissioner, an independent commissioner, and the Queensland Protection Commission will be a statutory body under the Department of Justice.
Attorney General, you mentioned that the Intelligence Hub will be staffed by people seconded from the Department of Justice, Child Safety, Youth Justice and Queensland Police. Are you confident that the state will have enough resources to head up this Intelligence Hub, considering one of the key recommendations, even in the In Plain Sight report, was bolstering resources in specifically police and CPIU investigation units and so on?
Yeah, look, absolutely. And that's why, it is such a big announcement. We're announcing a new commission, $250 million over the next 4 years, making sure we get those agencies to work together. We must continue to go forward with a different strategy, a different way to protect children. It hasn't worked in the last decade. It hasn't worked in the way that children have been falling through the cracks, offenders offending in plain sight. So whatever we need to do, we will continue to do. And it is a great question, because that's why I'm so pleased the Treasurer's in the room. He has put a focus on this because we know that it is a big ask, but we have to get this right.
Attorney General, you talked there about appointing a commissioner to this new body. Who is that going to be? I imagine there's quite a few people in here who might be vying for that job.
I'm quite sure there are. But look, on that, I really do want to again thank Luke Twyford, who is the Commissioner of the QFCC. He just does an incredible job. This in plain sight report, like I indicated, the board, the contributors to in plain sight, I take my hat off to them. It was amazing. It was distressing briefings that I was getting, let alone them working that each and every day. We will let you know when that decision has been made, but know that we are continuing to work hard each and every day. We are not waiting for the new Queensland Protection Commission legislation and framework to be set up. The QFCC is continuing its vital work that it does each and every day. And again, I want to thank Luke Twyford for that work and his team.
Again, Attorney, just on that figure that you've attached to the commission, the $250 million over 4 years, I think you just said, is that for the commission alone and its new or seconded staff costs, or does that also extend to the intelligence hub, the IT system? Is it for the whole package, I suppose?
Well, as it's been costed out, as they come on, of course, we may need to even ask for more money. But that $250 million over the forwards has been allocated from our costings to ensure that we can commence the Queensland Protection Commission, that we can kickstart the intelligence hub, but importantly, get the work done, the pre-work done, so we can start the intelligence hub in March 28.
On a related subject, but perhaps slightly different, this week, Guardian Australia has published 2 stories about child deaths that have included serious concerns about the way the coroner's court investigated the cases. In one case, relevant evidence was withheld.
Sorry, Andrew, can you just start again? We missed the beginning.
Oh, did I? I'm sorry. Apologies. We've recently published 2 stories this week about child deaths that have included serious concerns about the way the coroner's court has investigated the cases. In one case, relevant evidence was withheld from the inquest. In another, the coroner never held an inquest. Do you have any concerns about the way the coroner's court handles these cases? And do you hold the same concerns that the system is failing those most vulnerable victims and their families?
In relation to any coroner court matter, I need to start by saying they're extremely distressing for the families and the victims that have to wait for a loved one to be examined and to, at times, be investigated through the coroner's court. I mean, that's hugely distressing, which is why we have made sure in last year's budget we invested in a victims service embedded into the coroner's court. I'm not going to, if it's an ongoing matter, it's difficult for me to comment. I'm not able to comment on an ongoing matter, particularly if it's being investigated. And the decisions not to investigate are with the coroners. Now, the coroner's court is a court, and it is, it would be inappropriate for me to criticise or comment on an ongoing investigation. But to note, as Attorney General, I have power to order or open an investigation if requested, and that is not a decision I ever take lightly. In fact, it is a very difficult decision because obviously each family has their own reasons. And in relation to victims, and if there is an example of someone that hasn't been treated well through the coroner's court, I would really like to know about it, so we can learn from it and obviously do better. But I can't necessarily comment on that matter. I know one of the matters you're talking about is under current investigation.
Okay, we probably have time for...
I was going to ask, the Mason Jet Lee matter, which I think might be the other one, which is a 10 years old matter, there are significant issues or claimed issues with the police response to that matter. Is that a sort of matter that you might consider reopening an investigation of?
Look, I would really... It is important that the role of Attorney General must take these matters seriously, and I do, each and every one. The matters that have been highlighted in that horrific death of Mason Jet Lee and the failures that surrounded it was one of the reasons why we've also commissioned the Commission of Inquiry into the child safety system here in Queensland, because the system has to change. And we've got the 52 recommendations that Minister Cam, Minister Simpson and I are dealing with, going through methodically through our Cabinet subcommittee, and we'll report back in relation to that COI within the 2 months. But when it comes to publicly commenting on reopening an investigation, that's just not something I'm going to do on the fly. But thank you.
Just quickly, can I just check with the Protection Commission and then the hub? Will there be a deliberate recruitment drive to employ more staff to help with the transition?
Well, look, with the skills that we will require, that will be a matter for the Commissioner. But what I'll say is this: we have some of the most amazingly energised, excited people within our departments who have been, and there's some of them in the room, who have spent the last months working on making sure we can get this right, making sure that we develop a system that can capture the type of offending that we're trying to capture to protect those kids. So excitingly, there's already heaps of people that will automatically go to the Queensland Protection Commission. I know that some that I've met, they're already very excited. But also there's this energy and excitement within some of the teams within Department of Justice, and some of the ones that we've spoken to in some of the other departments, because they, on a day-to-day basis, are frustrated with the silos that we have in government. And look, I was in opposition, as you all know, for a long time, but we always talk about silos of government. Well, this is the Crisafulli government breaking down those silos to make sure that we protect kids. So I think we'll have really excited people who want to come and work for the Queensland Protection Commission that are already well embedded in government.
So can you guarantee no job losses through
Absolutely.
this overhaul?
We'll need more.
One more.
Attorney, can I just quickly clarify how this new commission will work alongside the Queensland Family and Child Commission? Will the QFCC operate the same as it's always been, or will some of their role be transferred over to this new commission?
It is a great question. So the Queensland Family and Child Commission will be absorbed by the Queensland Protection Commission.
Okay, great. Thank you.
Any more details of that work and how that will go?
So basically, thank you. I could.
A lot of details to get.
I know,
today.
a lot of details. There is so big. We didn't want to maybe we can come back and explain more. But no, so the Queensland Family and Child Commission, the Child Death Review Board, do incredible work. And the Child Death Review Board, in case that's the next question, they will remain as the Child Death Review Board and continue their vitally important work that they do, horrific work that they do, but much needed. The Child and Family Commission, so the QFCC, will be absorbed completely, or you could say the Queensland Protection Commission is going to absorb the QFCC, but their roles and everything that they do will continue in the manner that they are. Every single one of their staff will go from being a QFCC to a Queensland Protection Commission staff. So it's the same with blue cards, yellow cards, reportable conduct scheme, making sure that we get those departments who are all those agencies within the Department of Justice that are all working towards one angle, which is the protection of children and the identification of risk, will sit under the Queensland Protection Commission.
All right, that brings us to the end of our lunch. Please join me in thanking the Attorney General.
Thank you.